Değerli konuklar, Türkiye Cumhurbaşkanı
Distinguished guests,
Cumhurbaşkanı
President of the Republic of Turkey has honored the hall. Thank you.
basın mensubu arkadaşlarımıza teşekkür ediyoruz. Yerlerine davet ediyoruz.
We would like to thank the press members.
Değerli konuklar,
Distinguished guests, this is the 60th anniversary of the Constitutional Court, where our President Recep Tayyip Erdogan honored us with his participation. I'd like to welcome you. Distinguished guests, I'd like to invite you to honor our martyrs and the founders, Mustafa Kemal Atatürk, and we will proceed with the national anthem.
teşekkür ediyoruz.
Thank you very much. His Excellency Mr. President, the Constitutional Court, which started its work on April 25th, 1962, with three main tasks: the supervision of the implementation of the norms in the Constitution, the supervision of political parties, and the judgment of the Supreme Court, and the examination of individual applications, was included in its duties and powers with the constitutional amendment made in 2010. And I'd like to leave you alone with our video specially prepared for the founding anniversary of the Constitutional Court.
1961 Anayasasıyla Avrupa'nın ilk anayasa mahkemelerinden biri olarak hayatımıza giren Türk Anayasa Mahkemesi 25 Nisan 1962 tarihinde çalışmalarına başlamıştır. 1961 Anayasasıyla Anayasa Mahkemesi'ne normların anayasaya uygunluğunun denetimi, siyasi partilerin denetimi ve Yüce Divan yargılaması olmak üzere 3 ana görev yüklenmiştir. 2010 Anayasa değişikliği ile Anayasa Mahkemesi'ne temel hak ve özgürlüklerin ihlal edildiği iddialarını değerlendirmek üzere bireysel başvuruları inceleme yetkisi verilmiştir. Bu değişiklikle temel hak ve özgürlüklerin korunmasında yeni bir evreye geçilmiştir. Bu kazanım sayesinde vatandaşlar ve ülkemizde bulunan yabancı uyruklu kişiler, Anayasa ve Avrupa İnsan Hakları Sözleşmesi'nde ortak koruma alanında bulunan temel hak ve özgürlüklerin kamu gücü tarafından ihlal edildiği iddiasıyla Anayasa Mahkemesi'ne bireysel başvuruda bulunma ve giderim sağlama imkanını elde etmiştir. Anayasa Mahkemesi 10 yıllık bireysel başvuru tecrübesinde yaşam hakkından adil yargılanma hakkına, kişi hürriyeti ve güvenliği hakkından ifade özgürlüğüne, özel hayata ve aile hayatına saygı hakkından mülkiyet hakkına kadar bireysel başvuru kapsamındaki her hak ve özgürlükle ilgili ilke ve esasları belirlemiştir. Bu ilkelerin uygulanmasıyla da bireylerin maruz kaldığı birçok hak ihlalinin giderilebilmesi sağlanmıştır. Bireysel başvuru, Anayasa Mahkemesi'ni salt norm denetimi yapan bir kurum olmaktan çıkartıp insana dokunan bir niteliğe kavuşturmuştur.
Bireysel başvuru Türk hukuk tarihinin en büyük reformlarından biridir. Bunda hiç şüphe yok. Ve Türk hukuk sistemi bakımından çok büyük bir kazanımdır. Ve bizim vazifemiz bu kurumu etkili bir şekilde gelecek nesillere taşımaktır. Bu büyük bir sorumluluk, büyük bir görev. Bu görev bir yandan Divan-ı Mezalim ve Divan-ı Hümayun gibi kurumları ihdas eden ve başarılı bir şekilde yüzyıllar boyunca uygulayan ecdadımıza karşı, diğer yandan da gelecek nesillere karşı bizim sorumluluğumuzdur.
Anayasa Mahkemesi bireysel başvuruyla birlikte hak eksenli paradigmayı benimsemiş, kararlarıyla ülkenin temel haklar ve özgürlükler standardının yükseltilmesine çok önemli katkılar sağlamıştır. Bu sayede mahkeme, ülke gündemini uzun süre meşgul eden başörtüsü, evli kadının soyadı, usulsüz telefon dinlemeleri ve bunların basına sızdırılması, internet haberciliği, uzun tutukluluk, gizli tanıklık, yargılamalarda dijital verilerin kullanımı gibi pek çok önemli konuda kararlar vermiştir. Anayasa Mahkemesi, 15 Temmuz darbe teşebbüsünün başladığı ilk anlarda yayınladığı duyuruyla anayasal düzene karşı her türlü demokrasi dışı girişimi reddettiğini ve demokratik hukuk devletinin yanında durduğunu ifade etmiştir. Türk anayasa yargısında yeni bir evrede 2017 anayasa değişikliği ile getirilen Cumhurbaşkanlığı hükümet sistemi ile başlamıştır. 9 Temmuz 2018 tarihinde yürürlüğe giren anayasa değişikliği ile Cumhurbaşkanlığı kararnamelerinin anayasallık denetimi yetkisi Anayasa Mahkemesi'ne verilmiştir. Böylece Anayasa Mahkemesi'nin görev alanı yasama işlemlerinin yanında yürütmenin ilk elden düzenleyici işlemi niteliğinde olan Cumhurbaşkanlığı kararnamelerinin yargısal denetimini de içine alacak şekilde genişletilmiştir. Bugün Türk Anayasa Mahkemesi, Avrupa Konseyi ve Avrupa Anayasa Mahkemeleri Konferansı'ndan Asya Anayasa Mahkemeleri ve Muadili Kurumlar Birliği'ne, Afrika Anayasa Yargısı Konferansı'ndan Dünya Anayasa Yargısı Konferansı'yla İslam İşbirliği Teşkilatı'na üye devletler Anayasa Yargısı Konferansı'na kadar üyesi ve kurucusu olduğu pek çok uluslararası kuruluş ve ikili ilişkiler yürüttüğü 30 ülkeyle işbirliği içindedir. Anayasa Mahkemesi, anayasanın verdiği görev ve yetkiler çerçevesinde temel hak ve özgürlüklerle hukuk devletini korumak ve geliştirmek amacıyla çalışmalarına devam etmektedir.
Sayın Cumhurbaşkanım,
His Excellency Mr. President, distinguished participants, we are celebrating the 60th anniversary of the Constitutional Court in a more grand manner. And in this context, 60 years and 60 articles souvenir book, 60th anniversary commemoration coin, and 60th anniversary stamp and envelope, 60th anniversary special Constitutional Court views, and commemorative forest and 60th anniversary album were prepared, and we will be opening with the presence of our President Recep Tayyip Erdogan, and we are really honored. And now I'd like to invite the first speech, Mr. Zühtü Arslan, the President of the Constitutional Court of Turkey.
Sayın Cumhurbaşkanım,
His Excellency Mr. President, esteemed guests, first of all, I would like to greet you all wholeheartedly, and I would like to welcome you to our ceremony held on the occasion of the 60th anniversary of the Constitutional Court, as well as I extend you all my most sincere greetings. Today, we are hosting the chairmen and justices of regional human rights tribunals from all over the world, and the representatives of international institutions, and presidents and justices of constitutional courts, councils of 26 countries. I would like to express once again my gratitude for hosting such distinguished guests in our country, and I'm really pleased to see all of them in our country. Well, maybe you looked at the pages because it's a very long speech and you think that it won't come to an end. I won't be reading all of the text, and it won't take long. And I will try to answer two questions. And I will be talking about the practical side and the theoretical side of constitutional courts, and also why do we have the constitutional court and what are the dynamics. The second question is, what does the Turkish constitutional court do? Because I am going to be evaluating the 60-year history of the Constitutional Court, and especially the last 10 years of the Constitutional Court. And when we look at the first question and the courts of constitutions, when we try to answer this, it is about maintaining justice and also protecting the basic rights and liberties. In all of the courts, not only the constitutional courts, our main objective of existence is to protect the basic rights and liberties, because only if you can maintain justice for the individuals, then we can maintain peace and welfare, and the states can continue to exist. Well, first, when we talk about the Ottoman history, and when we talk about the Fatih the Conqueror and all the other Ottoman sultans, they are always concerned about justice. And the presence of justice is the citadel of the state. And if you just can deliver justice to everyone, it is also related to power. And if you can maintain justice, then you can. Pascal, the famous philosopher, said, "If you don't have justice, then you will have tyranny." So you have to be just and fair, and so you have to maintain this balance. And of course, if you are powerful, you have to be just, and you need law, and you need constitutional law, so they have to come together in order to maintain peace. When you talk about the political authorities, when you talk about the governments, it's always about protecting the rights and liberties of the individuals, and it has become institutionalized for the last century. And there were 2 world wars, and there were massacres, and there were systematic rights violations. Therefore, we have set up regional and national courts, and together with this, the existence, the sole existence of an institution will not suffice to maintain peace and to maintain justice. So, and we need to guarantee the basic rights and liberties of the individuals. So, if you need to have functional constitutional court, there are two sine qua nons. The first one is external, the second one is internal. The external one is about the separation of powers in the Constitution. If you don't have the separation of powers, you cannot really protect the individual rights. And if you don't have the separation of powers, you cannot really talk about a constitution in the modern sense. With the separation of powers, first you need judicial independence, and also you need to have the independence of the constitutional court at the same time. So in order to have a strong constitutional court, you need to have the separation of powers, and it needs to be implemented. And the internal sine qua non is to be just. Well, the term just has two meanings. The first one is about justice, as you know, and the second one is to have the rights, to claim the rights of the individuals. So if first you need to determine the right, then you have to deliver the right to the individuals. So when we talk about equitability, of course you need to deliver the rights, and also you need to determine the right of an individual. Therefore, in all of the constitutional courts and their existential presence is about giving the rights to the individuals. But this will not suffice. The members of the Constitutional Court, the judges, the justices of the Constitutional Court should be fair at the same time, because you could only have justice with just people. But, to be fair and to be just is not really easy. And Nietzsche, in this sense, said, it's a virtue that is rarely seen in humanity. Therefore, no one has more of a right to our respect than he who possesses the drive and strength to justice. And according to Nietzsche, the hand of the just man who is competent to sit in judgment no longer trembles when it holds the scales. His Excellency, Mr. President, I would like to answer the second question for the rest of my speech. What does the Turkish Constitutional Court do? We are well aware of our function. We need to provide justice and protect the basic rights and liberties of the individuals. So we exert great effort. So I would really separate the history of the Constitutional Court into two: the first 50 years and the last 10 years. Indeed, the classification of the history of constitutional jurisdiction into two separate periods is in keeping also with the will of the Constitution, the Constitution maker establishing the individual application mechanism. It is explicitly cited in the legislative intent of the respective constitutional amendment and the report of the Parliamentary Constitutional Committee on the constitutional amendment proposal that individual application is a milestone in the Turkish constitutional jurisdiction. And in this report by the Parliamentary Constitutional Committee, it is indicated that the Constitutional Court so far perceived as a body protecting the state and the system in pursuit of the state's understanding will be considered as a tribunal which from now on renders judgments in pursuit of and efforts protection to the freedom. This was changed in 2010. And when we look from this perspective, the Constitutional Court of Turkey for the last 10 years has undergone an evident paradigm change with this introduction of the protection of the individual rights. As for the the last 10 years, I would like to just give you my remarks. So I'd like to take back for 7 years ago. I delivered my first speech in this hall, and 7 years ago in this hall during the conference, which was held on the occasion of the 53rd anniversary of the court, and at which we were honored by your participation, I expressed that the court was just at the very beginning of the process for a paradigm change. That was a long time way to be taken, and that this transition period must be completed and implemented in a consistent manner. This expression is also the reflection of the ultimate goal, so to be attained by the Constitutional Court under our chairmanship. And I would like to express my satisfaction that the paradigm change initiated upon the individual application mechanism has been fulfilled to a significant extent that would also cover the constitutionality review. In some of the rulings of the Constitutional Court, the rulings, the rights-based paradigm adopted by the court has led to the interpretation of the constitutional provisions in pursuit of fundamental rights and freedoms. And of course, we cannot leave aside the public security while protecting the rights of the individuals. Sometimes we are criticized, and because the public safety and the basic liberties and the rights of the individuals should be balanced. And while we are trying to protect this balance, our compass is the definition of justice by Mevlana. And because it is all about putting all the bricks to their own places. So while we are balancing, we are just trying to make sure that we are just balanced in our rulings. His Excellency, Mr. President, distinguished guests, and when we talk about the right-oriented paradigm, I'd like to give you some examples. The paradigm shift started with, we may say that it has been applied in two ways in practice. The first of them is the more liberal approach adopted following the predominance of this new paradigm with respect to constitutional principles concerning the state structure and functioning, such as separation of powers, state governed by rule of law, secularism, and democratic state. Secularism principle and its interpretation is open to discussion, but the court has ruled that the principle of secularism is not about imprisoning the person to his or her own internal world. The court has stated in this decision that the principle of secularism does not confine religion solely to the inner world of the individual, as well as allows for and secures the manifestation of religion and faith in community. As stated by the court, in a secular political system, the individual preferences as to religious issues and the choice of lifestyles steered accordingly are under the state's protection, but must be exempt from any interference of the state. So this has changed many things and has been reflected on many different rulings. And one of them was the hijab decision, the banning of hijab. And when we talk about probably the most explicit repercussion of the court's liberal interpretation of secularism may be found in the individual applications judgment, where the bans on wearing headscarf were found to constitute a violation. Pursuant to the rights-based interpretation of secularism pursued by the court, the headscarf worn by women in accordance with their religious faith is under the protection afforded by the freedom of religion and conscience enshrined in Article 24 of the Constitution. According Accordingly, in the case where the applicant, a lawyer, was asked to leave the courtroom for wearing a headscarf, the court found violations of the freedom of religion and prohibition of discrimination. Likewise, violations of the freedom of religion and the right to education have been found in a case where a student had been dismissed from the university due to the headscarf ban. Shortly, when we talk this in brief, the Constitutional Court, adopting a right-based approach, interpreted secularism as a constitutional principle which includes the practices prohibiting a certain belief of its exercise as well as the interventions forcing persons to do so, and which also ensures that people can freely exercise their religious beliefs without being exposed to any obstacles. And also the same applies to the principle of a democratic state. And Article 2 of the Constitution and the notion of requirements of the democratic order of the society, which is specified as a criterion for restriction in Article 13 thereof. According to the court, democracy necessitates a legal and political order that guarantees the fundamental rights and freedoms of individuals in the broadest sense. And especially the freedom of expression, as frequently stressed by the court, notably in terms of freedom of expression, the notions of requirements of the democratic order of the society, which is enshrined in Article 13 of the Constitution, requires that any restriction on a constitutional freedom will be imposed as a compulsory or an exceptional measure, and that it must be the last resort to the last measure to be taken. His Excellency, Mr. President, the Constitutional Court, in addition to making a liberal interpretation of the constitutional principles, has also interpreted the constitutional provisions regarding fundamental rights in a way expanding the protection realm of these principles. For instance, while Article 38 of the Constitution embodies no express regulation allowing for the retroactive application of more lenient criminal provisions, the Court has concluded through a right-based interpretation that more lenient regulations should be applied retroactively. When we are interpreting the Constitution from a liberal point of view, I think we cannot be aristocratic. So we have had many difficulties. The Constitutional Court, for the last 10 years, with its rights-based orientation, a court could be a guarantee of the basic liberties, basic rights and liberties without being aristocratic. And of course we have many rulings, and I won't be talking about the rulings of the Constitutional Court about the protection of the basic rights and liberties. And of course we have the rulings of the last 10 years, so I cannot really exhaust the list, but I don't want to try your patience. For the last 10 years, the rulings of the Constitutional Court has reached to all layers of society with its rulings. All the applications of the individuals from all layers of society were ruled. So Constitutional Court of Turkey has taken its stance in many of the legal issues that have been debated all over the world. And of course this paradigm shift did not really come to realization in a good atmosphere, because we have had extraordinary days, especially after the 15th of July treacherous coup d'etat attempt. There were around 100,000 applications to our Constitutional Court, but there was
kalmış ki bu meselelerin bir kısmının etkisi hala.
And because of the state of emergency, the things were really complicated, and the Constitutional Court has really exhausted its all efforts to solve the problems of the individuals. The state of emergency was a problem, but there are also new institutions which were established after 2017, and there were, and of course the basic principles were determined by the Constitutional Court, and while doing so, the Constitutional Court was not drifted away from the other constitutional courts of the countries. We have had good relations with other constitutional courts, and we just try to tell this to the whole world that we are working towards rights-based paradigm shift. So of course, we also made sure that we are going to make use of the good implementations and best practices all around the world. And I'd like to talk to you about the international forum. And our president has honored in 14th of December in Istanbul, Dolmabahce, and which was completed with the Bandung Declaration in Indonesia. And together with these, we have had also the Islamic countries' constitutional courts, and this initiative will be achieved, and hopefully we will have the second Congress of the Islamic countries' constitutional courts, and this initiative will come to an end at the end of this year. And as for the second initiative, we will not have to wait until the end of the year to conclude it. We will negotiate the declaration on the establishment of the Conference of Constitutional Jurisdictions of the Member States of the Organization of the Turkic States, in which member observer states of the Organization of Turkic States may participate in Dolmabahce on the 27th of April 2021. And just like the Türkay will be established, and we will just declare it to the whole world. And therefore, I hope that these two international forums will be beneficial for the constitutional courts, and this will also increase the solidarity between our constitutional courts. And at the very end, despite all negativities and challenges, we are fulfilling our responsibilities. Therefore, I would like to thank everyone, our vice presidents, our members and rapporteurs, and to all our members, I would like to thank them once again. His Excellency, Mr. President, the most important thing is to set the change and set the tone at the same time. Together with its own accumulation, we are making use of the accumulation of the other judiciary bodies and the academic world. And of course, we have set up the Constitutional Judiciary Research Center, and we have many symposiums, and we have many publications as well. And it is about the development of the rights-oriented approach. And I'd like to thank once again to my colleagues who are performing their duties in IAM. And I would like to conclude my remarks by saying that in terms of basic rights and liberties, as stated in the Constitution of Turkey, it's about the separation of powers. legislature, executive, and judiciary, which is specified in the preamble of the Constitution. I have to point out that such a cooperation is of particular necessary in dealing with the workload regarding individual applications. Indeed, on every occasion I reiterate that unfortunately the court has encountered the heaviest workload in its 60-year history. And as of today, we have around 49,000 individual applications. Not only the constitutional courts, we have a line of people lined up here for individual applications. We are receiving individual applications from 47 different countries. And of course, this individual application issue has become unmanageable. So I think we have to make sure that we overcome this problem, and the legislation should, the legislative power of Turkey should do its best in order to find a better way of solving individual applications issue.
Elbette yapılan yasal değişiklikler
Of course, the legal amendments will help us to solve this problem, but the workload on individual applications and its radical solution is to have the objective effect of the individual application. And first, you need to get rid of the violations, rights violations, and the reasons of these violations. So, as we have expressed on every occasion, the most efficient way to reduce this heavy workload is to eliminate the source of the violations. In other words, the statutory provisions as well as administrative judicial decisions found to have resulted in violations by the Constitutional Court should be annulled. Thus, similar further individual applications on violations may be prevented. His Excellency, Mr. President, the individual applications to the Constitutional Court, not only the individuals but also the institutions could also apply for securing their rights. And as a result of the division of functions and cooperation in terms of the protection of fundamental rights and freedoms, will contribute to the fortification of a democratic political order where power is allied with justice. And I'd like to once again thank to the founder of the Republic of Turkey, Mustafa Kemal Atatürk, and his friends. And before ending my speech, I would like to commemorate our late retired members. I also wish good health and prosperity to all members of the court. I wish that the symposium on interpretation of the Constitution in the protection of fundamental rights and freedoms we have organized on the occasion of the courts I'd like to thank everyone who have exerted efforts. And lastly, we will have the opening of the Constitutional History Gallery, and I hope that this will also be beneficial for the country. Our main objective is to this project is to introduce our constitutional history as well as the developments achieved in terms of the constitutional jurisdiction, pointing out to their milestones since the alliance until today, since the charter of the alliance until today. I hope that the information and documents exhibited in the gallery will be of interest and beneficial to especially our guests from abroad and the university students within the country. Once again, I would like to express my gratitude for your participation in our anniversary, and I extend my wishes of health and prosperity to all of you.
Teşekkür ediyorum.
We would like to thank Zühtü Aslan, the President of the Constitutional Court. And now our President is going to honor the Constitutional Gallery and will open the gallery. And then we would like other guests, our guests would to remain seated, but the protocol and the invitation only participants can come and visit the gallery. And thank you very much. And now we will proceed with the opening of the constitutional history.
Diğer konuklarımızı da bu taraftan efendim fuaye alanına davet ediyorum.
I'd like to invite to the exhibition hall our guests on the other side of the hall. Thank you very much.
Türkiye Cumhuriyeti Anayasa Mahkemesi'nin saygıdeğer başkanı.
Distinguished Chair of the Constitutional Court of Turkey, distinguished participants,
Temel hak ve özgürlüklerin korunmasında anayasanın yorumlanması konulu sempozyumun açış.
I would like to welcome you to our symposium. And first of all, I would like to invite you for a moment of silence to be followed by Turkish national anthem in order to commemorate the founder of the Republic, Gazi Mustafa Kemal Atatürk, our August martyrs, and our dear lawyers who passed away.
Saygıdeğer başkanım.
Honorable President, before starting the program, I would like to remind you that the symposium is broadcast live on the official Twitter page and YouTube account of the Constitutional Court, as well as on the corporate website. Dear guests,
Kurum ve kuruluşun katıldığı sempozyum.
Dear guests, our symposium is attended by 26 countries and 4 international institutions and organizations. We'll begin with the greeting speeches of the Honorable Presidents of the African Court of Human Social Rights, Algerian Constitutional Court, Azerbaijan Constitutional Court, Bangladesh Supreme Court, and Uzbekistan Constitutional Court. After watching the Constitutional Court introduction film. Our symposium will last for 2 days and will be held in 3 sessions. The first session will be chaired by the President of the Court of Cassation, Mr. Mehmet Akarca, and its subject is the impact of interpretation on determining the scope of fundamental rights and freedoms. The second session will be chaired by the President of Council of State, Mr. Zeki Yiğit. Its subject will be the impact of international human rights law on the interpretation of constitutional rights and freedoms. The third session will be chaired by the President of the Constitutional Court, Mr. Zühtü Arslan, and its subject will be the interpretation of the Constitution and comparative law. Sessions will be finalized with the question and answer sessions, and they will be followed by presentation ceremonies. The symposium will end with the closing speech of Mr. Kadir Özkaya, Deputy President of the Constitutional Court. Honorable President, dear guests, I would like to present the introduction film of the Constitutional Court. Actually, we have already watched the video and we will continue now. Mr. President, dear guests, I would like to invite the President of the African Court of Human and Social Rights, Imane Daoud About, to take the floor to deliver the welcoming speech. The floor is yours.
Your Excellency, Professor Zoht Aslan, President of the Constitutional Court of Turkey, Your Excellencies, Chief Justices and President of Honorable Judges of the Constitutional Court, distinguished guests and dignitaries, all protocol observed. I bring to you warm greetings from Mount Kilimanjaro, and more precisely from the judicial capital of Africa. I named the city of Arusha in Tanzania. I express my personal gratitude and that of the entire African court for being associated to this important event. Celebrating the life of an institution such as Constitutional Court illustrates the imperative to recognize the importance of justice in society. And doing so by bringing judicial minds from around the world further stresses the need for judicial dialogue. I find it relevant to note that Constitutional Court of Turkey has developed a tradition of judicial dialogue. I recall that my predecessor was already part of a similar engagement a couple of years back. Distinguished colleagues and guests, judicial dialogue has become a main feature of the globalization of law and justice. The language of law is intersectional and transversal. There is indeed a global agreement towards universalism of human rights and constitutionalism, especially in constitutional democracies. Today's event is also a celebration of such values to which the African Court fully adheres. As you are aware, the African Court was established in 1998 and has been operating as the only judicial institution of the African Union. The African Court's mandate to safeguarding fundamental rights and freedom, as well as values of constitutionalism, is derived from the very commitment expressed by African states under Article 3, G and H of the Constitutive Act of the African Union. Aspiration number 3, Agenda 2063 of the African Union, which can be considered as a coordinated regional integration plan for Africa's similarity, constitutes a pledge to the same value. These general pledges under the umbrella of regional integration are translated into more specific commitments under the African Charter on Human and People's Rights and the African Charter on Democracy, Elections, and Good Governance. Africa's Human Rights Charter is rightly considered to be a historical international instrument due to its unique features. The Charter speaks largely to fundamental rights and freedoms in both universal and African ways. Firstly, it provides for all generations of human rights as interdependent and correlated. Secondly, it uniquely provides for people's and groups' rights. Finally, it establishes the principles of duties to the community, to family and society. Africa's Human Rights Charter can be seen as a regional text of constitutional value because of its larger national recognition. Almost all African constitutions acknowledges the Charter either in the preamble or through an express or wholesale illustration in substantive provisions. This recognition has come to the fore in adjudicating cases, for instance, in situations where the respondent states before the African Court had recognized the principle of national consensus as such fundamental importance that the Constitution may not be amended without an agreement across political groups in the country. Distinguished colleagues and guests, it is in its recognition of the inherent link between human rights and many components of constitutionalism, the African Union adopted another instrument that may actually be considered as a regional constitution, at least from normative standpoint. This instrument is the African Charter on Democracy, Election, and Governance. African Democracy Charter indeed include pledges by member states of the African Union to principles such as the rule of law, democracy, independence of the judiciary, and good governance. In light of its broad material jurisdiction under Article 3 of its protocol, the African Court has determined that the African Democracy Charter is a human rights instrument in the sense that fundamental rights can be derived from the pledges that states made in the Democracy Charter. Some commentators have therefore suggested that the African Court plays the role of a regional constitutional court in Africa in respect of the protection it has afforded to fundamental rights and freedoms, including those related to democracy, the rule of law, and other components of constitutionalism. Now, permit me to share with you a few illustrations of how the African Court has contributed to safeguarding fundamental rights and freedom in Africa in the past 15 years. It is important to first mention that the African Court has adjudicated matters involving various issues and rights, including fair trial right, the right of political participation, such as participation in elections, and the operations of electoral bodies. The case law of the Africa also includes matters pertaining to the rights of life, rights to life, in connection to the mandatory imposition of the death penalty, the right to nationality, freedom of expression, as well as women's rights, namely inheritance and child marriage. Through its case law, the African Court has consistently endeavored to embrace an interpretation of norms that is progressive, purposeful, and liberal, while being contextualized and bearing in mind a margin of appreciation of states. These features are illustrated as follows. For instance, the court has used the theory of bundle of rights to admit matters and issues that had not been explicitly examined in national proceedings, where it is evident that domestic courts were or ought to have been aware of such issues. Another example involves instances where the court found that the mandatory imposition of the death penalty should be removed from the penal codes of a country because such provisions breach fair hearing by taking away from the judicial officers the discretion to consider circumstances that are specific to the accused person. Such other purposeful but contextualized interpretation involve affording certain types of reparations only in compelling circumstances, or using legitimate expectations to exempt the applicant from abiding from a too strict legal provision. In order to have more comprehensive grasp of the African Court or the courts of Africa, contributing to the interpretation of international human rights norms, I invite you to consult various volumes of the African Court Law Reports, which are available on the court's website. Distinguished guests and colleagues, as I conclude my remarks, permit me to congratulate our dear hosts, Honorable President Aslan and his team for convening this event to celebrate fundamental rights and freedoms through the prism of constitutional law and constitutionalism. Congratulations indeed for furthering judicial dialogue. In this vein, I would like to add that the share commitment to global cooperation for justice has inspired the holding every 2 years of the African Continental Judicial Dialogue, whose last edition was organized last November in Dar es Salaam, Tanzania. The African Court will be very pleased to have the Constitutional Court of Turkey, and indeed some of the apex judicial institutions here present, attend the next edition of the African Judicial Dialogue. Also permits me, Your Excellency, President, to congratulate you for reaching the 6th anniversary, which is so long, like an age of myself standing before you, of whom I'll be 60 after a few months. So this is an old court, and we wish you all the best, that wherever you come from, you'll be focused to make sure that human rights are there too in Turkey and in the entire world. Thank you again for inviting the African Court and for your kind attention.
Sayın Başkan'a konuşmalar için çok teşekkür ediyoruz. Konuşmalarını yapmak üzere şimdi de Cezayir Anayasa Mahkemesi Başkanı Sayın Ömer Belhaç'ı kürsüye davet ediyorum. Buyurunuz efendim.
Now I would like to invite the President of the Algerian Constitutional Court, Mr. Ömer Belhaç, to take the floor to deliver his welcoming speech.
Bismillahirrahmanirrahim. Vessalatu vesselamu ala afdalil mursalin. السيد رئيس المحكمة.
The President of the Constitutional Court, Mr. Zühtü Aslan. Distinguished judges and representatives and members of supreme judicial organs, bodies. Before starting my speech, I would like to thank you very much. I would like to extend my gratitude to you because you have invited us to this 60th anniversary of the Constitutional Court of Republic of Turkey. Taking this opportunity, you gave me the chance to visit my second country. Thank you very much. These are holy days, as you know. We are in the month of Ramadan, and I would like to extend my gratitude to you all. I would like to wish you a happy Ramadan, and I hope that God will help us and God will accept our fastings. Turkey and Algiers are two sister countries, and we are here for their well-being. And I'm here attending your 60th anniversary as the Constitutional Court of Republic of Turkey. And actually, I'm the first president of the Algiers Constitutional Court, so it is quite an honor for me to be here. Our Constitutional Court has been established just 6 months ago, and this is the essence of the political reforms our president directed for the foundation, for the establishment of our institution, and in in 2019, December 2019, we started to work on the constitution, and when we came to November 2020, we had the election for the deputies, the member of parliament, and then finally we had the establishment of the constitutional court, and we will have the local elections before us. The deputies will be also elected, and the members of the parliament will also elected. We are talking about new constitutional institutions, and Algerian constitutional court is really important, and our president attached great importance to reform activities, and this is the establishment of the constitutional court is actually a part of this reform path. And we are talking about actually it's the foundation of a rule of law, and we are talking about the fundamental rights, democracy, and we are focusing on this as a court, as a constitutional court, and cooperation among different institutions and bodies is also another issue. Our court is a really important foundation for all the other efforts. When we think about its features and responsibilities and duties, we attach great importance to this establishment. We have 12 members in our court, and 4 of them are appointed by our president, and the president of the court himself or herself is also appointed by the president, and 1 member is elected by the state council. This is the highest administrative judiciary body. The remaining 6 members are those academicians who are working in various universities in the departments of the constitutional law. So this is the composition of our constitutional court. And when we look at the special expert areas of the duties of the Constitutional Court, we can say that there are some specific topics we deal with too. We have different duties and responsibilities. We have responsibilities about checking whether the national or international international conventions or agreements are in compliance with the constitution, for example. And they also work as a court of mediation, and we try to find some solutions to these kind of cases. In addition to this, we are also checking national or local laws, and we look whether they are in compliance with the international conventions we are party to. And we are making some interpretations, of course, within the framework of the constitutional provisions. I'm really happy to be here with you as a participant. It is really great thing for me. This is a deep-rooted institution, and I'm really happy to be here at your 60th anniversary. And it is actually giving us hope for futures. Your activities, your decisions, interpretations are actually making a certain basis for our future acts. And this is we also have this activity, this event here is also creating a foundation for the cooperation between the Algerian Constitutional Court and Turkish Constitutional Court. in Algiers, we had the Algerian Constitutional Council, but now the things have changed. We have the Constitutional Court, and we carry out our activities in all branches. We continue our concerted effort, and in between two countries, we have many fruitful cooperations in terms of regarding constitutional law. And OIC has some. We have some cooperations with the Organization for Islamic Cooperation, and improvement of these relations is something we expect. We want to have, as we did in the recent past. This will continue in the future. We will continue making constitutional interpretations. We will interpret the fundamental rights and freedoms, and we will try to protect them. And we will continue to underline the importance, significance of the constitutional law. And constitutional law, the scope of constitutional law is another topic of discussion, a topic of study. The interpretation of the provisions of the Constitution is really important, and we are generally focusing on the fundamental rights and freedoms, and there might be some conflict, some problems between different institutions and organizations, state organizations, and we are trying to resolve these, mediate these kind of cases. We had the Constitutional Court, as I said, Council, as I said before. Now we have the Constitutional Court, and we have the duties and responsibilities and authorities of the Constitutional Council. And when we look at the previous 30 years, the interpretation, constitutional interpretation, was a topic of discussion. And our Constitutional Council made some interpretations as in the past, and in Algiers passed through some delicate political periods, and the Constitutional Council actually made some interpretation during this time. But in 2020 November, the Constitutional Court was established, as I mentioned, and we started to interpret the constitutional provisions. This is the main responsibility, duty of the Constitutional Court. And the parliament, the speakers or other people, members of the parliament, these are all important. We have a double assembly in our parliament, double councils in our parliament, and they all request for some interpretations from the Constitutional Court, and we have these authorities, we have this mandate, and this mandate will play a really significant role in striking the balance between different powers of the state. So constitutional organizations will be improved, developed in the future, in our opinion, and with the mandate of the Constitutional Court, fundamental rights and freedoms will be protected. We will work on these issues. The respect to the Constitution is something which should be embraced by all institutions and organizations. We are focusing on rule of law. So as a result, to conclude my speech, I would like to express my gratitude to you all. I would like to thank you, the President of the Constitutional Court and the members of the Constitutional Court of the Republic of Turkey. I would like to thank you very much, and also thank the participants. This is actually your 60th holiday, 60th festival, feast. not just the anniversary. Hopefully, you will be successful, more successful in the future. And today is a starting point actually for the cooperation between the two institutions of our countries. This is a first step for this cooperation. So brotherhood and values are really important for us. Thank you very much for your attention. I wish you will have the support of God.
Sayın Başkan'a
We would like to thank to the President for his remarks. And now, I'd like to invite President of the Bangladesh Supreme Court, Mr. Hassan Foyez Siddiq, to take the floor to deliver his welcoming speech. The floor is yours.
Bismillahirrahmanirrahim. Professor Dr. Zutu Arsalan, Honorable President of the Constitutional Court of the Republic of Turkey, my dear colleague judges from different countries, distinguished participants and legal scholars, ladies and gentlemen, Assalamu alaikum, good afternoon. It gives me immense pleasure to be here amidst honorable judges, eminent legal luminaries, and distinguished scholars from around the globe. At the very outset, I would like to express my humble gratitude to Professor Dr. Jutu Arsalan for inviting me to attend this symposium on interpretation of Constitution in the protection of fundamental rights and freedoms, held on the occasion of 60th anniversary of the Constitutional Court of Turkey. Ladies and gentlemen, the inherent dignity of every human being can be realized through the full and meaningful implementation of human rights and fundamental freedoms. Every human being has dignity by virtue of his existence. Every state is goal-oriented and claims to be strive for securing the welfare of the people. If individuals are unable to exercise their fundamental rights, life would be unbearable and meaningless. The judiciary is mandated to protect the rights and liberties of the citizen through judicial review and judicial activism. Nevertheless, we must realize that democracy, reasonableness, social justice, etc. are overchanging principles which provide linking factor for principle of fundamental rights. And that can be done when the judiciary takes the burden of interpreting the Constitution if and when requires. Distinguished guests, Constitution of Bangladesh embodies aspiration of social justice, brotherhood, and human dignity. Our Constitution works because of its generalities and because of the good sense of the judges when interpreting it. On this auspicious occasion, I feel the urge to mention one important decision of the Supreme Court of Bangladesh, where our Supreme Court courageously played significant role in protecting citizens' fundamental rights. In 1997, in the case of Dr. Mohiuddin Farooq versus Bangladesh, the Supreme Court of Bangladesh expanded the scope of bringing justice within the reach of the common people as well as to preserve constitutional order. The court said, I am quoting, the expression person aggrieved means not only a person who is personally aggrieved, but also one heart bleeds for his less fortunate fellow beings for a work done by the government or a local authority in not fulfilling its constitutional and legal obligations. Thereby, any public-spirited person is allowed to move the Supreme Court to vindicate a cause of the rule of law or to enforce the fundamental rights of any person, including any marginalized or excluded group. The Supreme Court of Bangladesh interpret and construe the Constitution to meet the needs of changing condition of our society so as to make it a living constitution. Since the commencement of the Constitution of Bangladesh, the Supreme Court has been performing its functions as the flag bearer of the constitutionalism and watchful protector of fundamental rights. Distinguished participants, this symposium, I hope, will provide a platform for a dialogue among the judges, legal scholars, and jurists around the world. Above all, new thoughts and ideas will be evolved. The discussion will open our mind and bring flexibility of our thinking. I strongly believe that the interactions among our colleagues from various parts of the world will foster new friendships of commitment to ensure justice for all. With these few words, I conclude here. May the friendship be long-lasting. Thank you very much for bearing with me. Allah Hafiz.
Sayın Başkan'a konuşmaları için çok teşekkür ederim.
We would like to thank the President for his remarks. Now, I would like to invite the Chairman of the Constitutional Court of the Republic of Azerbaijan, Ferhat Abdullayev, to the floor.
Hörmətli Türkiyə Anayasa Məhkəməsinin Başqanı Doktor Zütü Aslan, hörmətli məsləkdaşlar, əziz dostlar, icazə verin Azərbaycan Respublikasının Anayasa Məhkəməsi adından məsləkdaşlarımızı və əziz dostlarımızı Türkiyə Anayasa Məhkəməsinin yaranmasının 60-cı il dönümü münasibəti ilə səmimi qəlbdən təbrik edim və ən xoş arzularımı çatdırım. Azərbaycan Respublikası Anayasa Məhkəməsinin nümayəndə heyəti qardaş ölkənin Anayasa Məhkəməsinin yaranmasının 60-cı il dönümünə iştirak etməkdən son dərəcədə məmnun olduğunu bildirir. Bu görüşə bizi dəvət etdiyinizə görə şəxsən Sayın Zütü Aslan başda olmaqla Türkiyə Anayasa Məhkəməsinə minnətdarlığımı bildirirəm. Burada doğma simalar, səmimi münasibət görür və özümü kəndi vətənimizdəki kimi hiss edirik. Ölkələrimiz arasında bütün sahələrdə əməkdaşlıq, işbirliyi Azərbaycan Respublikasının Prezidenti Sayın İlham Əliyevlə Türkiyə Cümhuriyyətinin Prezidenti Sayın Rəcəb Tayyip Ərdoğanın mühüm tövhələri sayəsində gelişməkdədir. Bu il Türkiyə ilə diplomatik əlaqələrin 30-cu il dönümünü kutladıq. Aradan keçən 30 il boyunca dost və qardaş ölkələr həm sevincli, həm kədərli, üzgün günlərdə bir-birinin yanında olmuşlar. Bunu qəhrəman Azərbaycan ordusunun 44 günlük vətən müharibəsi ilə torpaqlarımızın işğaldan azad edilməsindən sonra duyduğu sevinclə Türkiyə bir daha göstərmişdir. Sevindirici və qürur verici haldır ki, bugün Türkiyə dövlətlərinin dünya dövlətləri sırasında həm geosiyasi gücünə, həm iqtisadi inkişafına, ekonomik gəlişiminə görə uluslararası arenada etkisi artmaqdadır. Türkiyənin bütün sahələrdə olan gəlişimi, həm də hüquq sahəsində də demokratik toplumun
and it is it is very important that the Court of Constitution is quite important today, and because we know that the Constitutional Court is working for the rights and liberties of the individuals. And Turkish Constitutional Court is quite experienced in this sense. And it's also protecting the Constitution. And today we are celebrating the 60th anniversary of the foundation of the Republic, the foundation of the Constitutional Court. And of course it is about the protection of the norms and also the interpretation of the norms. And with the interpretation, it is very important to investigate all the proceedings and the rulings of the other courts. And of course, the Court of Constitution is showing us that the rights and liberties of the individuals are under protection. So when interpreting the rulings and the norms of So, of course, we are talking about the final decision and final interpretation of the norms. And therefore, in some cases, on the basis of the inquiries, in order to verify the compliance of the legal norm to Constitution through official interpretation, the Constitutional Court gives to the norm a new life and saves it from elimination. And as a result, it is possible to avoid a vacuum, and thus the court can apply the norm interpreted within the new meaning. Once again, I cordially congratulate you on the 60th anniversary of the establishment of the Turkish Constitutional Court, one of the most important and fundamental institutions of the legal system, and wish you success in future endeavors. Finally, I would like to underline that I'm glad to see you, all of you, in person after a long time. I convey you to each of you my best wishes from your friends in Azerbaijan. I wish all of you health and peace and prosperity. Last but not least, I would like to invite the President, Mr. Isa Mulubek, the chairperson of the Uzbekistan Constitutional Court.
Assalamu alaikum. Hurmatli rais, hurmatli hamkasblar, hurmatli xonimlar.
Distinguished chairpersons, the ladies and gentlemen, distinguished participants. First of all, I would like to thank to His Excellency Zühtü Arslan, the President of the Constitutional Court of Turkey, for inviting the delegation of the Constitutional Court of Uzbekistan. I wholeheartedly extend my greetings, and by taking this opportunity, I'd like to salute the reporters, the justices of the Constitutional Court, and also the academics in cooperation with the Constitutional Court. And I just congratulate them for the 60th anniversary of the establishment of the Constitutional Court of Turkey. They have responsibilities, honorable responsibilities of protecting the basic rights and liberties of the citizens of Turkey, and I wish them success in their endeavor. And of course, we have comprehensive strategic cooperation between Uzbekistan and Turkey, and we are continuing our efforts of high-level cooperation between our parliaments, between our institutions and ministries. We have intensive works and cooperation between our agencies and institutions, and of course, and under the auspices of our heads of states, brotherly cooperation and friendly cooperation is crucial in overall cooperation. Of course, we have economic, political, and social relations between our countries, but in turn, we have also cooperation in justice and in legal authorities. We are exchanging best practices, and also the courts of Uzbekistan and Turkey has started in 1998, and it has been going on ever since. And the exchange of information and correspondence between our courts are present, and we are also visiting our countries. And in 2007, the Constitutional Court celebrated its 25th anniversary in Tashkent, and there was an international conference for the celebration, and Mr. Zühtü Arslan has delivered a speech as the head of delegation, and in the 56th celebration, 56th anniversary of the Turkish Constitutional Court was also participated by Uzbekistan. And in 2021, in December, Mr. Celal Akıncı has had bilateral talks in Tashkent. Our cooperation between the courts nowadays is with the Asian constitutional courts. The Asian countries' constitutional courts union gathers every year for exchange of experience by the Turkish Constitutional Court in the summer school. Our justices participate to this summer school, so we would like to thank once again to the Turkish Constitutional Court. If you allow me, I would like to congratulate the members of the Constitutional Court and the President of the Constitutional Court for the 60th anniversary, and we will continue to cooperate from now on, and we will continue to further and develop this cooperation. That's all I want. And I would like to reiterate and highlight the fact that such a festival, such a symposium is held in Holy Ramadan, and I am glad and I'm honored. We are almost going to live the Eid Mubarak, and I would like to congratulate you all once again. Thank you very much.
Çok teşekkür ediyoruz.
We would like to thank the President for his speech. His Excellency, Mr. President, we will continue with the first session, which is the effect of interpretation in determining the scope of fundamental rights and freedoms. This is, and the first chairperson is Mehmet Akarca, President of the Court of Cassation. The second panelist is Dr. Yusuf Şevki Hakemez, member of the Constitutional Court, and we have Bertil Emrah Oder he is the Dean of the Koç University Faculty of Law, the Associate Professor Dr. Oya Boyar from Marmara University Faculty of Law, Department of Constitutional Law, and we have Ömer Gedik from Atatürk University. They will have their presentations. Thank you very much.
Oturumu başlatmak üzere sözü Yargıtay Başkanımız Sayın Mehmet Akarca'ya bırakıyorum. Buyurun başkanım.
Anayasa Mahkememizin kıymetli başkan ve üyeleri, yurt dışından gelen çok kıymetli Yüksek Mahkeme Başkan ve üyeleri, değerli katılımcılar, değerli meslektaşlarım, hepinizi sevgi ve saygıyla selamlıyorum.
Distinguished court members, distinguished President of the Turkish Constitutional Court, distinguished members of the Constitutional Courts of the foreign countries, I would like to greet you all with respect.
Anayasa Mahkememizin 60. kuruluş yıl dönümü sempozyum.
I am really pleased to celebrate the 60th anniversary of the establishment of the Court of Constitutional Court of Turkey. We have guests from 26 countries, and we have also many esteemed guests from respected international institutions. As we are moving forward to have a better world, and I'd like to thank all of our colleagues and guests who have the same objectives. In terms of democracy, the Constitutional Court is one of the strongholds of the protection of liberties, basic rights and liberties of the individuals. And I once again would like to congratulate the 60th anniversary of the establishment of the Constitutional Court. They have exerted an enormous amount for a better judiciary, and I once again would like to congratulate Mr. Zühtü Aslan and the court members. Constitutionalism is about binding rules and principles, and of course these rules should be abided by the governments, by the officials, and we need to also protect the rights of the individuals. Today, the separation of powers principle has some problems, but media, some interest groups sometimes could intervene in the judiciary and also weaken the authority of the judiciary. The weakening of the authority of the judiciary is also ruining the right to a fair trial for the protection of the human rights and the basic rights, and we need to be awake in order to protect the rights of the individuals. In a democratic society, the rulings could also be criticized, but not implementing the rulings of the Constitutional Court or other courts may really harm democracy and the judicial system. The European Human Rights Commission is really attaching great importance to the authority of the judiciaries in all of the countries. As the law people, I think we need to work more on this. As for the other rules and principles of judiciary and also the laws, we need to interpret all these laws, and the interpretation of the law cannot be arbitrary. And of course, if the judiciary safety is quite important, because it could not have many different interpretations of different judges, and so we need to have the principles to be interpreted in a principled manner. And the interpretation of the constitutional law is crucial here, because the interpretation will have a great effect on the rulings and the procedures. And as of the 19th article of the constitutional law, there are some factors such as the international agreements, and of course the international agreements are binding for us. And in this session, we will be talking about the effect of interpretation on the protection of the basic rights and liberties. So, as time goes by, we would like to give only 10 minutes for each speaker, then we have a Q&A session. And I think we have great speakers who are well experienced, and also we will try to give them the floor. And I'd like to give the floor to Mr. Şevki Hakkemez, member of the Constitutional Court. Thank you very much. Distinguished chair, and distinguished participants, I'd like to welcome you all. And I will be talking about my topic will be the comment of the Constitutional Court extending the scope of rights and freedoms in the norm control decisions. The Constitutional Court in our country, now we are celebrating the 60th anniversary, but of course we have the norm control, and also we are now open to individual applications. After the amendment in 2010 about the Constitutional Court, we had different criticisms and evaluations, especially for activism. And we will start with the first interpretation. The Professor Dr. Mehmet Turhan has been the rapporteur for the Constitutional Court, and now he's in a university. And of course, the activist role of the Constitutional Court in order to expand the liberties and the basic rights. We'll start with the quotation. There is a strong weapon in the Constitutional Court. It is the interpretation of the Constitution. And if we are talking about the protection of the individual rights and liberties, it's not an organization to be influenced by different institutions. We need a liberal environment to come up with the right interpretation. This was an article, and in 2010, the individual applications were accepted by the Constitutional Court. And with the constitutional amendment in 2010, the abstract rules and principles, while interpreting the individual applications by guaranteeing the basic rights and liberties. Of course, we were also interpreting the norms, and then we just proceed with the rulings. So we have libertarian rulings of the Constitutional Court. These libertarian rulings of the Constitutional Court is about the norm control. Our Mr. Zühtü Aslan has mentioned about this norm control, and of course we have four decisions, the four decisions of the four rulings of the Constitutional. The first one is to control the ruling of the Constitutional Court. In 2018, there was a ruling of the Constitutional Court in the 36th amendment of the Constitutional Court is to have the right to seek for a fair trial, and also right to due process and right to a fair trial. And while doing so, the Court of Constitution with the Court of Cassation we have the 154 and 155th amendments, and when the Constitutional Court is producing this right, we are also referencing to the international agreements, to the 7th protocol, 7th sub-protocol of the European Human Rights Court, and the Constitutional Court is bound by the 7th protocol, 7th annex, but it's also wider than the 7th protocol of the European Human Rights Court and declaration. We have had detailed examinations. In this ruling, we have adopted this ruling, and we continue to implement the same rule. And I have one example here, if you allow me. And especially for the construction auditing companies, we have administrative fees and fines, and the first instance. Courts may come to a ruling, but it might be overruled by the Court of Constitution. And also in the penal law, we have different laws about the retrospective fees and fines. It is in the law, but it's not in the constitutional law. And of course, we have the retrospectivity is quite important, but there are some precedences, and of course we do agree. We do fully agree and refer to the European Human Rights Commission and Court, and of course retrospectivity is a constitutional principle, and the Constitutional Court in the 38th Amendment of the Constitutional Court about fines and crimes has adopted this. It is aligned. It is aligned with the European Court of Human Rights, and thirdly, not being prosecuted for the same crime. And since I have only 10 minutes, I'm just trying to be really fast so that I can conclude my remarks. And about this principle, we have an individual application in Ünal Gökhan, and in the 36th Amendment of the Constitutional Court, we had this in norm control, and that was the description. Nobody, if not arrived to a final verdict, can be prosecuted with the same crime. And of course this was against the principle, and in order to have this principle emerge, we have 5 prerequisites. And of course, in the we have the precedences in the Human Rights Court of the European Commission, and of course we have misdemeanors as well. And this we need to
tekrar bir ceza ile ilgili yargılama sürecinin işletilmesi.
It is because of the gist of the action.
Kavramsal kargaşaya sebebiyet vermemek için şunu ifade etmek lazım.
It is the first we need to look at the merits of the case. So one person could be could be fined and punished twice, but this person, if not proven to be guilty determinately, cannot be judged for the same crime for the second time. So if there is a new evidence, this is an exception. And of course, if there is a fallibility which might result in changing the verdict, this is another exception. And of course, these should be all interrelated. In the Constitution, in this ruling, this is, for instance, in tax law, and of course there are tax misdemeanors, and of course this does not violate the principle that I have mentioned. I have 1 or 2 minutes, and it's about the public services. And as you know, in our constitution and in all international documents, we have this regulation. To enter to public service is only about entering the service, but this does not really provide any safety and security, but this is another right, so we need to have the norm to safeguard this principle. And of course, we have systematic interpretation, we have historical interpretation, and also we look at the international documents and their interpretations. So we have this approach. If you enter to the public service, it's not only about entering, it's also being given the sack out of the service. So those who enter to the public service, first, you need to be notified when you are going to be discharged from the service, but it's about entering the service, not only entering, but it's also performing this duty. So when doing so, of course, about the civic rights, and we have another interpretation, because entering to the public service, it's about entering to the service, performing the service, and also being discharged the service is under the umbrella of the judiciary processes. So we have the other rulings in parallel. The result is that the Constitutional Court, within the constitutional system, it's about the norm control, about the individual application rights, the basic rights and liberties. It's quite protective, and also we need to interpret the constitutional amendments with the contemporary needs of the people. So we need to have a dynamic constitutional court in our respective countries. Thank you very much.
Sayın Hakemesi hocamıza çok teşekkür ederim.
We would like to thank Mr. Hakemez. You used your time wisely, and you talked about something really important, and you tried to summarize it. You conveyed it in a concise manner, and we are trying to protect the freedoms as the Constitutional Court, and we all know that. And of course, in interpretation principles, it is adopting new modern principles, modern methods too. First one is the right to demand checking the provision and also retrospectivity. We talked about that, and retrial or rejudge. You cannot be rejudged for the same act. We talked about that, and also he talked about entering into the public service and getting out of the public service. He talked about that, and I would like to thank you very much. Now we will continue with Professor Dr. Bertil Emrah Öder. The floor is yours. Thank you very much, Mr. Moderators. I would like to thank you very much for organizing such an important meeting, and I want to thank you very much for inviting me to this event. I wish a happy birthday to our Constitutional Court. We have a 60-year of institutional history, and this is a great example for the world. And we are working on public institutional consolidation, and this is the people generally say that 40 years are really important to have some certain history. The age of 40 is also important, especially for being assigned to some certain posts, duties. So we are talking about 60 years now, and hopefully the Constitutional Court will continue its responsibility and duties for many more years, and we will try to work with them, and we of course want the Constitutional Court to enrich its case law and content. Maybe we can also think about the deeper past. In 1927 and 1926, we had the magazine, a periodical from Istanbul University, and there were some discussions in this periodicals, because behind this 60 years we also had some know-how from the first years of the Republic and also final years of the Ottomans. There are short articles about the controlling the constitutionality of the laws, and in 1950s Refik Gürün focused on this issue, and he tried to have this constitutional law in Turkey, but it was not successful back then. For this reason I would like to utter his name. The history of the constitutional law is rich, and I would like to extend my gratitude to all the academicians, academics, and all the judges who participated, contributed to the history of the Constitutional Court. So I have 10 minutes. I know, but I told what I can talk about in this 10-minute time. And in all my own career, I focused on interpretation and augmentation and normativity. Now I would like to use a different lens, and here the Constitutional Court has some judicial policies which are becoming more noticeable in the recent years, and I want to talk about them. When we look at the current status in Turkey, and when we make some comments about the constitutional courts in the world, there are similar situations actually in Turkey and other countries in terms of constitutional courts. There are similar discussions, and I can talk about three main headings which may be related to us. One of them is, as mentioned by the President, is that the policy choices of the political will and political ruling since the beginning of the 2000s and up to 2010. The political dimension of the Constitutional Court was discussed, and the government of the judges was discussed, aristocracy was discussed, and we were talking about the judiciary as a tool for using a certain power, and we also had some discussions about the policy affecting the judiciary, and different approaches were discussed in politics and in the judiciary area fields. At the end of the 18th and in 1990s, there were some decisions about hat scores, and we can see the similar discussions back then too. Political governments and their effect on the judiciary is also another topic. We are talking about the politicization of the judiciary, or alignment with the political rulings can be listed as some phenomena which were being discussed, The judicial behavior is important here. The ideological decision making is actually connected to this phenomenon, and we are talking about two different judicial attitudes. and normative analysis lose its essence in the face of political activism. We are talking about this alignment or being silenced, and sometimes because of excessive politicization, some decisions are not being made or some are made. There are some examples of this kind of decisions. There is more than political interpretation in those provisions. Intra legem or extra legem law creation is actually the form with which we see that phenomenon. And sometimes the limits are pushed, but socially, actually, the court should resolve an issue, but we see a discussion around the court itself. And the limits of the law can be pushed by the judiciary, and a connection of the judiciary with the rule of law can be questioned, and sometimes we can see that the judiciary is not acting in accordance with the rule of law. There are some examples, and there were some large public discussions, and we can see them from time to time in different areas, fields. Political impact, political effect is important here. There might be some prejudices, deeply rooted prejudices, and there are some polarized discussions. And in the recent years, we see some issues related, some issues around these things around the world, and in Turkey. The negative stance towards judiciary is becoming more noticeable in the democracies. The judiciary is becoming a focal point of political discussion. This is increasing day by day. Democratic problems is one of the reasons, and some populist governments are taking the power in all around the world, and this might be one of the reasons. The political discussions and the tensions as a result of that actually should be resolved, and the courts are sometimes using classical interpretation methods, and sometimes they develop some judicial policies other than these general classical interpretations. We have 4 main judicial policies. I think we can see that. First one of that is the individual applications, the political. There are some topics which are politically and socially important, and Constitutional Court is reiterating actually the trust towards itself. And this is actually strengthening the judiciary. There are some sensitive issues, and we're underlining the judiciary selectivity. There are mega policy cases, and there are some judiciary agenda strategies which are designated. Some cases are suspended, and human rights, European Court of Human Rights is also an important actor, and sometimes they're going in dialogue with the European Court of Human Rights, and they are working in coordination with them. And finally, since this is mainly happening for the sensitive issues, consensus or sometimes the vote of the president is changing the provision, changing the decision, and this is the importance of that is on the increase. In this final cluster, I can say that the Constitutional Court is experiencing some criticisms, and there are some discussions. But despite all these discussions, I think that there is a strategy for judiciary strengthening, and this individual application is strengthening that. The backlash, there might be a backlash, of course. There have been some cases which was experienced by the Constitutional Court as a backlash. The other courts did not follow or resist the decisions of the Constitutional Court, and this is actually connected with this judiciary strengthening and in the case law of the independent individual application, we can see that its constitutional court is focusing on the social order, democratic social order mainly. In the last 4 years, both the norm control and individual application and decisions are sometimes topic to the discussions, the criticisms, but they are more related, more closer, in a more close relationship with the democracy. So this is a really important phenomenon, and the relation between the constitutional court and the democracy is getting stronger. And in the norm control especially, there is a demonstration law, demonstration provision, which prevents people to make demonstrations on the intercity roads, and there was a decision about the Constitutional Court. And there's another issue, violence against women. The final case law of the 6284 law was really important in that regard. It is a really important structural case law in terms of taking precautions against violence against women, and this covers everyone, for the students, the women at home, and it turned into the Constitutional Court turned into a popular actor as a result of these decisions. And finally, I can say that in the constitutional law, the limitation of limiting the political will, political ruling, is the essence. We need to call the powerful to be just, as the Constitutional Court, and actually the President of the Constitutional Court has talked about that in his speech with great examples. But there is some other important issue. It is really hard to make the strong, make the powerful be just, but the Constitutional Courts should be strengthened, and constitutionalism can be more effective in this way, and I believe that this is a strengthening strategy, and I really suggest the Constitutional Court to continue in this path, and I would like to congratulate the 60th anniversary of the Constitutional Court. Thank you very much. Thank you very much, Betül Emrah Oder. I would like to thank you very much for this presentation, and we talked about the basic fundamental rights and freedom, and we talked about the sensitivity of the constitutional courts in protecting these freedoms and rights. Constitutional court is actually quite similar to other courts in the world, but we have some difference. Being popular brings about a risk. We should be very careful about that. Of course, individual applications are really important, and Constitutional Court is taking really important steps. Now you talked about alignment and silencing the judiciary. If we talk about the past concept, you can see you could see that the Constitutional Court aligned more previously. In these issues, our Constitutional Court has made really great decisions, and we are really happy about that. We are really grateful about that. We have the individual applications now possible, and from time to time we have the conscience. We are focusing on the conscience, and the judges are focusing on the justice. And I would like to thank you very much for this great presentation. Now we will continue with the Associate Dr. Oya Bayar. The floor is yours.
Sayın Başkan.
Thank you very much, distinguished chair. It's an honor to be here in the 60th anniversary of the establishment of the Constitutional Court, and it is the main protection of the constitutional state, and Hans Kelsen has predicted and envisaged this importance. It is very important to have the constitutional courts in respective countries. Well, my presentation will be 13 minutes, but I'll try to finish it in 10 minutes. My topic could be a little bit theoretical. My presentation could be theoretical, but of course I will have some rulings at the end. But my investigative question is about the interpretation between the constitutional law interpretation and law interpretation. And of course, the legal interpretation and constitutional interpretation, what is the difference between these interpretations? Because there might be two explanations. The first one could be the theoretical. The interpretation theory here is changing the constitutional interpretation of the constitution, the legal interpretation, and interpretation of the law. They are interchangeable. So I will be talking about the theoretical means first, and secondly I will have a comparison, and we will have a thesis, and we will have an exception of the United States. Then I will have a comparison. Of course, there are two different theories of interpretation. As many of the participants are well aware, and of course there is a meaning in the text, and the law person is just interpreting it. And of course the interpretation of the laws and the interpretation of the constitution might be different. So there might be three different arguments, of course. Sometimes you could say that the constitution is more obscure than the other laws, or it might be called as a main text. So of course, first of all, you need to first describe the content, and when you talk about interpretation as knowing, they are different. Textual analysis, historical analysis, and systematic analysis or interpretation are different. Of course, we need some extra interpretations. So there is a difference in quality of the interpretation. But sometimes the interpretation is related to the interpreter of the text.
Sanı yorumu arasında aslında niteliksel bir farklılık olmuyor. Yorumcu açısından bir farklılık olabiliyor.
There might be a different interpretation when considering there are different interpreters, and because the president is an interpreter of the constitution, the Grand National Assembly is the interpreter of the constitution. So when they are using their own authorities, they are also interpreting the constitution. So there might be some different descriptions of constitution, and of course according to Willis, the main feature of the constitutional interpretation is that it determines the hierarchy between the constitution and other legal norms by saying what the constitution is. The decision of the And of course, there are since the nature of the constitutional interpretation cannot be determined independently from the concept of the constitution and the legal system, I will also give you my own interpretation. Of course, we have Turkey has accepted continental system, and of course, when we look from this perspective, and of course the responsibilities and the role of the Constitutional Court is about the norm and the norm production, because when different institutions are performing their own duties, they are also interpreting the Constitution. And of course, we have the Court of Cassation, Court of State, and of course they have their own interpretation of the Constitution. But when we talk about the interpretation, it must be done. Why? Because each justice is giving a verdict, and of course this is not abstract as law. This is tangible. But when we think so, in a hierarchy, a judge, I'm not talking about the justice in the Constitutional Court, when they are giving a verdict, first they are just deciding on their own responsibilities and authorities. Then, since they are putting the norms, which is a decision norm, just like the regulation of the Constitution on the policymakers, they need to abide by the 13th Amendment. Of course, it's the interpretation of the 138, but they need to have a proper interpretation in alignment with the 13th Amendment. So, of course, they are putting a norm in each and every case, but they need to be in alignment with the 13th Amendment. This is the norm hierarchy, but of course the interpretation of the Constitutional Court is also binding for the other courts. Another observation about the constitutional interpretation, of course, we have some general rulings. Therefore, our interpretation is generalized. Some courts' decisions are more specific, but the rulings of the Court of Constitution is general and abstract when compared to the other courts' decisions and rulings. And at the same time, the rulings of the judiciary is becoming more tangible. When it becomes tangible, this becomes more important in terms of the Constitution. I'm not sure whether I'm on time. And there is another example from the United States of America. We are talking about quantitative and qualitative interpretation of the Constitution and interpretation of the law. What do I mean by that? We have the precedents, for instance, and when we talk about the constitutional interpretation, for instance, Roe White ruling is nowadays discussed in terms of the integrity of an individual. This is still in discussion whether to be changed or not. the reason to change this ruling in the Constitution. It is very hard to change the Constitution of the United States of America when the Supreme Court decides, just gives a ruling, then it needs to change with the Senate, within the Senate. And of course, when we talk about the legal interpretation, they abide by the precedents. So the solid structure of the Constitution is one factor, and the efficacy of the Constitution. And also there is the method called originalism from the United States of America, and the state regime is also shaping the Constitution. What we say is that in United States we have a law from the common law, and we have the written law, and we have, and so the judges have different interpretations of the law. And of course this also shows us how traditions are quite important. But when we talk about the continental Europe, this also shows us why is it important to have the Roe White decision might be revoked. And the Court of Constitution has the authority to annul this ruling, this decision. And in terms of, this is my last sentence. So Court of Constitution is a guarantee for rights. When we talk about the Constitution of 1961, the legislature was really in a bottleneck in order to legislate, but the most important function is to establish the Constitutional Court, and it's the 60th anniversary of the establishment of the Court of Constitution. We would like to thank Oya for her presentation, and she just focused on Constitution and how the legal text interpreted differently from the Constitution. And of course she gave examples from the United States of America, and our President, Professor Dr. Zühtü Aslan, has given this example. In our Constitution, secularism is the same, but in 2012, when before the individual application was accessible, and we had a libertarian ruling that the headscarf or hijab cannot be banned in anywhere. And also about the religious courses in the high schools. There are also some individual applications for the religion courses in schools. Of course, we are just trying to protect secularism, but there is a different interpretation of the law, so that we are expanding the liberties of the individuals. So that's why until 2010, there are two different historical eras of the Constitutional Court, until 2010 and after 2010. So we have transformed the Constitutional Court to be the guarantee of the liberties and individual rights. Our last speaker, Dr. Ömer Gedik, you have the floor. Thank you very much.
Thank you, Mr. Chair. I'm really excited today, and I focused on interpretation between 2010 and 2013, and now I'm here in the first panel with the authors of the three important publications I used during my studies on interpretation. When I was selecting the topic, my teacher said, can you do this? But now I can see that it is really hard to make an evaluation about the interpretation method of the Constitutional Court. After 2012, maybe we can say that the Constitutional Court started to make some individual decisions, individual part application decisions. And there were some differentiating differences in the checking system about the process, and Constitutional Court has many different and interesting decisions by Constitutional Courts. One of them was 10 days ago. It was in the official gazette. As far as I can remember, it was in the April 15th, and there was a storm in social media. People have not started to write about that topic, but the Constitutional Court is criticized highly, and I will take where Oya Hanım left. Of course, the court does not need my protection, but or witness me as a witness, but I would like to talk about the activism, judicial activism. We have sometimes we are focusing on the fundamental rights, and we are trying to carry carry further the human rights. You know, human rights are open for development, and we're not talking about third generation rights. At the end of 70s, Kararvasek started to use this third generation, but currently we're using these terms of this term of third generation rights. So we need to follow the constitutional courts, of course. Oya Hanım talked about Kensen, and I can also talk about Michel Trope too. And Trope sees the judge of a constitution as a co-lawmaker. So maybe some of you will be angry with this wording, but he says that it is quite effective. So the judge is really effective, and we need to separate the understanding the norm and putting a certain meaning to norm. Because we try to understand the norm, but nowadays giving a meaning to the norm duty is actually assigned to the constitutional judges. And we can have different approaches, of course, to this topic, and we have some decisions made with a realistic approach. In 1993, there was a decision. There was also another decision, and in 2008 we know there was a similar case, but since 1960s making these kind of refusal decisions with interpretations. So I believe these are actually positive, but in 2016, Constitutional Court stopped this activist approach, and I believe this is negative. I will talk about the type of decision. I think this is quite courage. This requires a certain courage from you. I'm aware of that. And in January and February, there were some decisions, and I believe these decisions require a new heading, new title. I don't know whether there are other opinions about that. Constitutional Court, when canceling a norm, it acts in a way that a provision is cancelled in the law, as it is actually not there. But this decision, which was published 10 days ago, was highly debated, and the Constitutional Court is criticized. And Mohammed Özekes wrote an article, he wrote an article on the social media. I expressed my gratitude to him. He shared the introduction and the conclusion of the article, and he says that the decision is incoherent and dangerous and pushing the boundaries, he says that. But for me, it is a coherent decision. And in the last 10 years, Constitutional Court is making decisions about that. This year, in January and February, did the same. These are the ones I detected. There is also another one in 2015. We can increase their numbers. I will just develop on one or two of them. He says that this is not coherent, but I believe it is coherent. And the final decision about the law, legal courts law, has been really highly debated, but for this reason people perceive it as if this is the first time the Constitutional Court is doing that. He says that it is hitting the boundaries, pushing the boundaries, but when we think about the realist interpretation, it is quite suitable for the modern approach. And he also says that it is a dangerous decision. No, we can say that it is rights-based decision. So I will try to look at that decision. Law on court proceedings has the article 341, and the first sentence of the second paragraph was change without cancelling or changing any words. It narrowed the meaning of the sentence. So it was stating that 1 year later, if there is a reason for delay, after the 1 year period, if there are reasons justifying the delay, a lawsuit can be filed within 1 month starting from the disappearance of the reason. This is the provision. The court decided that this provision could be unconstitutional when applied to children, and in this context, it is annulled its application to children. So this is a limited cancel. We can call this cancellation with interpretation. Maybe we can call this in this with this title. And when doing this, the Constitutional Court did not touch any word of the norm and narrowed its meaning, or it limited its meaning, or it put a certain principle. So this is a different approach. But the Constitutional Court may cancel the provision as a whole, but it didn't. The first sentence of the second paragraph of the Article 303 can be cancelled as a whole. So I believe this is a different approach. This was done in 2020 for the Turkish Civil Code. This was for the Article 303, paragraph 4, and it said that this cannot be applied to children. In the norm, you cannot find the word child, but the Constitutional Court is just narrowing the meaning and limiting the topic. So we can say that actually we have a new type of norm which is narrowing the rule or limiting the norm, or conditional cancellation, we can call it in one of them. What could the Constitutional Court do? Is it taking the place of the lawmaker here? There were some discussions about that. I believe the Constitutional Court did the best did the best thing. If they waited for that, this will be an individual application. A constitutional court can make a pilot decision, and this pilot decision can be used in order to eliminate these rights violations. But why should the constitutional court should wait? Isn't it its responsibility to prevent these violations of rights? So this kind of decision making is actually a new approach. And in the last 10 years, these are generally coming before the court with some objections. Objection cases, and constitutional court can use the individual application mechanism and can make the control of the objection norm, and with this is a very positive result, since we have the individual application in our lives. This is an example of that. Constitutional court. We are talking about a 60-year history, and I wanted to make an evaluation about the 60-year history of the Constitutional Court, but we have time limitations. But I want to add one thing. The President divided the time period for the Constitutional Court for the first 50 years and for the final 10 years, in which we have individual applications, but we can have a different separation for this history too. We have different constitutions for 1961 and 1962, and the constitutional courts were affected by these the new constitutions. I've been warned about the timing by the moderator here. In San Francisco, for the establishment of the United Nations, they got together, and also there was a revolution in Portugal, and these were all related to the improvement of the human rights and also internationalization, and also the Constitutional Court has an important role before against the authoritarian ruling governments. And finally, I want to say one word, one sentence. You talked about the age of 40. The Americans say that the 60th year of their marriage is the year of emerald. And this is the emerald year of the Constitutional Court, so I wish you a good year. Thank you. We would like to thank Dr. Ömer Gedik for this great presentation. He talked about a different perspective, and we talked about the Courtof degree first instance, and as you all know, the objection ways can be used. I would like to make an explanation for those who doesn't know. We have this control or check of the objection way, and now the Constitutional Court is also using that approach in the individual application, and they're quite similar. And understanding the norm and giving the norm a meaning, or adding the norm a meaning are different things, and the Constitutional Court is actually now giving meaning to the norm. And in the court procedure law, there was an example decision by the Constitutional Court, and also for the Civil Code. We will have some questions if you have. It is already 5 p.m. Yes, now you can have the floor. Do you need a microphone? We need to limit the questions because of the time. I would like to extend my gratitude. I'm the chief reporter of the norm control of the Constitutional Court. I would like to thank you very much for the presentations by the panelists, and I would like to ask my question. My question is to Bertil and Ömer. You know, we have some refusal decisions with interpretations where we are discussing whether they're binding or not. In the recent years, the Constitutional Court has a rights-based approach, and when we think about that, the court, the Constitutional Court can provide. The decision by the Constitutional Court, are they binding, or the courts should take that into account, take the decisions into account? Thank you very much. I'm really happy to hear that this cancellation with interpretation topic is being discussed here. There is an case law based on the civil code. First of all, the judiciary authority is not intervened. We talked about this headscarf issue, and this turned into a large political discussion. But the Constitutional Court, even before this case law and after this case law, made some decisions, decision of refusals with interpretation. In these kind of refusals with interpretation, I can say that they are they are showing respect to the law, and in the comparative law, we have some problems, may have some problems about equality, the principle of equality, or if we have an actual, if we cannot have the actual equality, they can have this kind of decisions of refusal with interpretations, or decisions of cancellations with interpretations. And the Constitutional Court can use if it is the only option for the Constitution, if you do not have any other option for making any other interpretations, then it should be binding. But there might be some cases, there are more than one interpretation options which are suitable, which are in line with the Constitution, and our Constitutional Court decided to choose one of these interpretations which is still in compliance with the Constitution, and the other judicial organ chooses another interpretation which is still which is also in compliance with the Constitution. But if there is just one interpretation, then it is binding. But about refusal or cancellation with interpretation, I can say I totally agree. This is actually supporting the lawmakers or the legislative organs. But I know that the discussions are still ongoing. Thank you very much. Would you like to add something? Actually, Bertil reasonably explained the topic. If we have more than one interpretations, it should not be binding, but we should also say that this is a directive to the legislative organ. So the legislative organ should follow the decisions and the rationales of the Constitutional Court, and the decisions by the Constitutional Court should be in parallel with the laws issued by the legislative organ. And I would like to underline another thing. We don't have that actually in Turkey, in Portugal, and Hungary, and Germany. We have a structure. They have a structure, and this refusal or cancellation with interpretation is a new topic, and they can also check, the Constitutional Court can also check whether it is violating the constitution or not. Of course, I'm not talking about an order or a directive direct to the legislative organ. It should be risky, but at least it may give some information about how it should be interpreted, or the problematic parts in the law can be underlined in order for the parliament to amend this problem. So this is my opinion about cancellation with interpretation. If there is just one single interpretation, it is binding. But if opens the, if it is possible to have more than one interpretation, then it is not binding. But this is so unlucky because since 1962, the Constitutional Court has been making this kind of decisions. Is there any other participants who would like to ask a question? Okay. There are no other people. Of course, we have time limitations, and it is a holy Ramadan, as you all know. And because of this, we will finalize this session today. And I would like to congratulate the 60th anniversary of our Constitutional Court, and it is one of the most important guarantees of the rule of law with the other judiciary organs. And for this reason, this activities by the Constitutional Court are quite important for us, and I would like to thank the judges for their efforts, activities, and I wish you success. And this is the end of this first session today. Distinguished participants, we would like to thank Mehmet Akarca, the President of the Court of Cassation, and we would like to thank the panelists. We will have a flag session. Now I would like to invite Zühtü Arslan, the President of the Constitutional Court.
Sayın Başkanım. Sayın Başkanım. Katılımcı ülkelerimiz için bir hediye takdimimiz olacak.
We will present a gift for the participating countries. İrem.
Değerli misafirlerimiz,
Distinguished participants, we will present gifts for the participating countries. Please take your seats.
Kesim listesine göre anons edilecektir diye bir duyuru yapalım ya. Onu bilsinler de. Şimdi bak herkes ayağa kalksın.
katılımcı ülkelerimizden Afrika İnsan ve Toplum Hakları
Now I would like to invite Ms. Imane Daoud About to the floor from Courtof, Africa, Human and Social Rights.
Sıradaki ülkemiz Angola
Angola, Chair of Constitutional Court, Laurunda Prezeres Monteiro Cardoso. Croatia,
ediyorum. Buyurunuz efendim.
Albania Constitutional Court President.
Azerbaycan Anayasa Mahkemesi Başkanımız Sayın Ferhat Abdullayev'i davet ediyorum. Özbekistan var.
Bundan keyin.
Ya üzgünüm, sırayla gidiyor çünkü alfabetik. Bangladeş Anayasa Mahkemesi Başkanımız Sayın Hasan Fuaz Siddiqui davet ediyorum. Bosna Hersek Anayasa Mahkemesi Başkanımız Sayın Mato Tadic'i davet ediyorum. Bulgaristan Anayasa Mahkemesi Başkanı Sayın Pavline Stovanova Panova.
Croatia. Which country? Croatia.
So sorry. Cezayir Anayasa Mahkemesi Başkanı Sayın Ömer Belhac'ı davet ediyorum. Okay.
Tristva. 32 or 22? 22.
Yes. Cibuti Anayasa Konseyi Başkanı Sayın Abdi İsmail Hersi'yi davet ediyorum. Filistin Anayasa Mahkemesi Başkanı Sayın Muhammed Abdelgani Ahmet El Haşk Kasem'i davet ediyorum. Gürcistan Anayasa Mahkemesi Başkanı Sayın Merab Turava'yı davet ediyorum. Karadağ Anayasa Mahkemesi Başkanı Budimir Spanovic'i davet ediyorum. Buyurunuz efendim. Kosova Anayasa Mahkemesi Başkanı Sayın Gresa Caka Nimani'yi davet ediyorum. Kore Anayasa Mahkemesi Başkanı Sayın Nam Seok Yu'yu davet ediyorum. Kuzey Makedonya Anayasa Mahkemesi Başkanı Dobrila Kaçarska davet ediyorum. Buyurunuz. Moğolistan Anayasa Mahkemesi Başkanı ve Asya Anayasa Mahkemeleri ve Muadili Kurumlar Birliği dönem başkanı Sayın Namjil Çimbat'ı davet ediyorum. Özbekistan Anayasa Mahkemesi Başkanı Sayın Mirza Ulubek Abdülsalamov'u davet ediyorum. Sırbistan Anayasa Mahkemesi Başkanı Sineza Marković'i davet ediyorum. Buyurunuz efendim. Kırgız Cumhuriyeti Anayasa Mahkemesi Başkan Vekili Sayın Karbek Duşev'i takdim ediyorum. Buyurunuz efendim. Avrupa İnsan Hakları Mahkemesi Yargıcı Sayın Saadet Yüksel'i davet ediyorum. Buyurunuz efendim. Endonezya Anayasa Mahkemesi üyesi Sayın Eni Nurbaningsih'i davet ediyorum. Hırvatistan Anayasa Mahkemesi üyesi Sayın Ingrid Antičević Marinović'i davet ediyorum. Kuzey Kıbrıs Türk Cumhuriyeti Yüksek Mahkemesi üyesi Sayın Mehmet Türker'i davet ediyorum. Filipinler Yüksek Mahkemesi üyesi Sayın Emil Lazaro Javier'i davet ediyorum. Buyurunuz efendim. Filipinler Yüksek Mahkemesi üyesi Sayın Emil Lazaro Javier'i davet ediyorum. Tayland Anayasa Mahkemesi üyesi Sayın Tevikit Meganindis'i davet ediyorum. Filipinler Yüksek Mahkemesi üyesi Sayın Emil Lazaro Javier. Venedik Komisyonu Özel Temsilcisi Gianni Buccuccio davet ediyorum. Buyurunuz lütfen. Afrika Anayasa Yargısı Konferansı Genel Sekreteri Musso Laraba'yı davet ediyorum. Musa, peki. I'm so sorry, sir. Kamerun Anayasa Konseyi Genel Sekreteri Sayın Joseph Ase Malegu'yu davet ediyorum. Buyurunuz efendim. Sayın Joseph Ase Malegu. Maldivler Yüksek Mahkemesi Genel Sekreter Yardımcısı Sayın Faysal Edim'i davet ediyorum. Buyurunuz lütfen. Tacikistan Anayasa Mahkemesi Asistanı Sayın Shonin Valizoda'yı takdim ediyorum. Buyurunuz efendim. Sayın Başkanım, değerli konuklar, mahkememizin 60. kuruluş yıl dönümü nedeniyle düzenlenen temel hak ve özgürlüklerin korunmasında anayasanın yorumlanması konulu sempozyumumuzun 1. oturumu sona ermiştir. Anayasal hak ve özgürlüklerin yorumlanmasında uluslararası insan hakları hukukunun etkili başlıklı 2. oturumumuz yarın saat 11'de başlayacaktır. Tüm konuklarımıza katılımları için çok teşekkür ediyor. İyi akşamlar diliyoruz.